in the OECD Convention against bribes given to foreign officials in the course of commercial transactions. Today we have a very impressive panel. In essence, here we have heads of anti-corruption bodies of major international conventions, both universal conventions such as the UN Convention and regional conventions and specialized conventions as the OECD Convention, for example. We also have representatives from the business community. We have 8 speakers in total and only 1 hour and a half of time. Therefore, I am not going to introduce all the speakers in turn now, but I will briefly introduce each one of them before I give the floor to each one of them. I think that you all have had an opportunity to read the introductory text devoted to our panel. There are a number of issues that we would like to raise here, but of course the speakers will touch upon other topics apart from those that we have formulated as a sort of a prompt in our announcement. Well, we have quite a few international instruments. Their implementation is versatile. It includes monitoring procedures. Sometimes we come across situations where what is adopted as part of one international instrument is not quite in line with our obligations under another international instrument. Sometimes the situation becomes even more confusing when the business circles ask us how shall they interpret those innovations that are introduced by international anti-corruption instruments. Let us listen to what our speakers have to say about the work of their organizations and conventions. Maybe there are problems related with overlapping spheres or contradictions between conventions and national legislation. Maybe such problems do not exist, and if they exist, what kind of measures can be taken to overcome them. So this probably this is it from me, and I think we will try to manage to finish our discussion at 10:30. At 11:30, sorry. At 11:30 we have a presentation of the International Anti-Corruption Academy, which will happen on the main staircase. I would like all the people present at our panel discussion to visit the presentation of the Anti-Corruption Academy. This will be a continuation of our discussion here. And if there are any questions related to the work of the Academy, it would be wise to ask those in the course of that presentation. So, I would like to ask the speakers to stick to a 10-minute limit. Please try to concentrate on the most important things so that we can maintain our schedule, give the floor to everyone, and probably leave some time for a Q&A session. Thank you very much. Now, I would like to give the floor right away to the advisor to the President of the Russian Federation, the person who is directly in charge of anti-corruption work coordination in the Russian Federation, head of the Commission, whose task is to coordinate the work of various government bodies while fulfilling various obligations and various conventions. Sergei Dubik, you have the floor, sir. Thank you very much, Maxim. Dear colleagues, I would like to thank you for giving me this opportunity to participate in such an impressive alignment of international lawyers. This forum has become an important event not only for lawyers in Russia, but for the international legal community as well, and for me it is a great privilege to be able to speak here. In my short presentation, I would like to concentrate on the implementation of international conventions and their incorporation in Russian national legislation. Over the past 20 years, as you all know, issues related to the fight against corruption have become key at all international fora. And probably we should not reiterate that the corruption is a challenge for the socio-economic development of practically all countries. Starting from, proceeds from corruption are also used to finance terrorism, and they're related to other crimes such as trafficking in human beings, arms trafficking, and others. Therefore, the international community has worked out both universal and regional mechanisms of combating corruption and created appropriate formats for their implementation. In this country in particular, on the board of anti-corruption body headed by Mr. Ivanov, we have a commission that coordinates the work of various bodies of government in their work aimed at fulfilling our obligations, our obligations under various conventions. It was created in 2009. It is headed by yours truly, and we also interact with major international bodies such as the United Nations, OECD, GRECO, the International Anti-Corruption Academy, and others.
Кратко остановлюсь на основных направлениях нашей работы.
I would like to briefly describe our work because it is directly linked to our today's topic. One of the major instruments in this sphere is the United Nations Conventions Against Corruption, adopted in 2003 and ratified by Russia in 2006. Russia actively participates in the work of the Conference of countries parties to the UN Convention. In 2015, this conference is going to be held in Russia, as you know. We have already set up the organizing committee. We have established contacts with the federal bodies of authority, NGOs, the civil society, and altogether we are preparing this important event in Russia. In 2009, with the assistance of our leading experts, a mechanism was worked out for the interpretation and incorporation of this convention. So in 2012, the survey of Russia's implementation of convention was finished, and according to the experts, the legislation in Russia is in line with the highest international standards in this sphere. We participate in regional cooperation as well. We interact with the institutions of the Council of Europe. On the 25th of July 2006, Russia ratified the Convention of the Council of Europe on criminalization of corruption. And in 2009, we signed an additional protocol to this Council of Europe Convention. Now the national plan for anti-corruption work has included road maps for the implementation of this additional protocol to the Convention on Criminal Liability for Corruption. And we also are party to the Convention of 1999. In 2007, we joined the Group of Countries Against Corruption, GRECO, which monitors the implementation of anti-corruption standards of the Council of Europe by member states. Russia has been taking a very active participation in the sessions of this organization. We have a representative, Mr. Yusupov, on the board of GRECO. Russia has already had 3 rounds of assessment, and we successfully completed rounds 1 and 2. In contrast to a number of developed countries who are much higher than Russia in corruption ratings, but for example Sweden and Germany, after those assessments were subjected to intensified monitoring. In Russia, we do not have any monitoring bodies of GRECO. So all this coincided with development of the major directions of anti-corruption policies in the Russian Federation, and we managed to take into account the Convention requirements of the Council of Europe and Russian anti-corruption legislation. Our cooperation with the OECD is also developing quite dynamically. The main legal instrument of this organization is the Convention against bribing officials in the course of international commercial transactions. This is a convention dating back to 1997. In 2011, we fulfilled the major requirements of this convention by introducing appropriate amendments, and in 2012 we acceded to this convention. The task force on anti-bribe work is the main monitoring body, and we will have to go through 3 phases of monitoring related to the implementation of conventions requirements. Maxim has undertaken a very difficult task of leading our delegation within the framework of our cooperation with OECD. We went through the first phase of monitoring by the task force of the OECD, which assessed the compliance of Russian legislation to this particular international convention. We received 12 recommendations. The second phase of monitoring is ongoing. Experts from the US and Slovenia evaluating the situation in Russia. They started this work on the 12th of May. They are assessing the effectiveness of Russia's implementation of OECD convention. Anti-corruption work is also we actively participate in the work of the Financial Action Task Force dealing with money laundering. We control the accounts of public figures, and this convention was implemented in Russia when we adopted a package of legislation aimed at controlling financial expenses and accounts of officials and politicians. We also pay a lot of attention to anti-corruption work within the framework of the Commonwealth of Independent States. At the initiative of Russia, we launched the establishment of an anti-corruption council of the CIS. This proposal was adopted by CIS countries, and the President of the Russian Federation in April this year signed an order that Russia ratifies this agreement. We pay a lot of attention to anti-corruption work within the framework of G20 and G8 summits. So the G20 has introduced a revolutionary measure whereby people charged with corruption crimes cannot assume various posts. We also try to evaluate the impact of corruption on economic growth. Dear colleagues, I think that a well-balanced approach to the implementation of international norms and their incorporation in the legislation. A good example of this work in this area was shown in Russia. The implementation of the convention, taking into account Greco recommendations, the Council on Anti-Corruption work worked out the Code of Conduct for municipal and government officials. Based on this model code, in all national, municipal and regional bodies, appropriate guidelines were adopted, and job descriptions now include a requirement to adhere to these requirements, and there is liability for failure to do so. So we introduce appropriate amendments in various laws of the Russian Federation, which helps us to unify the status of municipal officials of various levels, and as well as corporate officials, and we have a unified system of bans and restrictions for all of them. Two latest decrees regulate the procedure for submitting information on income and expenses by officials and various high-ranking managers of corporations. Well, certain amendments were introduced into the law on bank secrecy. A new system of submitting information on income and expenses by state officials have come into force. We can now seize and confiscate property which was acquired from unknown sources and not be accounted for by the official in question. The latest decree of the president provides for the protection of whistleblowers. Such a person cannot be dismissed without a preliminary consideration of this issue on the Committee for the Conflict of Interest, and also other measures of support can be offered to whistleblowers. The business community has also made very important steps in this direction. In September last year, the business community worked out the anti-corruption charter of Russian businesses and the roadmap for its implementation, which was highly evaluated by the international expert community. I would like to draw your attention to Article 13.3 to the law on anti-corruption work. It was adopted last year. This is an amendment to a previously existing law, and all the international experts highly evaluated this particular regulation, because no other country includes such provision as we have now in our legislation. I mean, Anti-Bribery Act and so on. So within all the organizations, irrespective of the form of ownership, have to set up appropriate bodies of fighting corruptions within those organizations. This is just several examples. And in conclusion, I would like to draw your attention to the following. The implementation of international conventions into Russian legislation should not be a one-off affair just aimed at creating some external effect. This work should be ongoing. It should take into account legal traditions of Russia, our realities, and our mentality as well. And such an opportunity is provided to us by the requirements and regulations of international conventions to which the Russian Federation is a party. Thank you very much for your attention.
Thank you very much, Sergei. Now I would like to give the floor to a person who was responsible for organizing of the mentioned Anti-Corruption Convention of the United Nations, after which he became a secretary of the participating states of this convention, Mr. Vlasis.
Mr. Chairman. And allow me to start by expressing my most profound gratitude and the gratitude of my office for the opportunity that you're giving to me and to our office to be present in this very impressive forum. You mentioned yourself, Mr. Chairman, the universality of the UN Convention Against Corruption. I will start with that. Indeed, there is strength in numbers, and now the UN Convention Against Corruption has 166 states parties. Saudi Arabia was the last one to ratify and to deposit on the 29th of April. So it has virtually more than 2/3 of the entire membership of the United Nations on board. So that is part of its strength. Its universal scope, its universal application. But the other part of its strength comes also from its comprehensive nature. Rarely you will find an international legal instrument, particularly in this field, where you will see the breadth and scope of its provisions complementing each other and covering so much ground. The architecture of the Convention is also of particular importance. It covers every stage of the multifaceted effort to combat a phenomenon as complex as corruption, from prevention to criminalization to international cooperation, and in a unique feature, an entire chapter devoted to asset recovery. I could be speaking for much longer than we have, Mr. Chairman, about the Convention and about its intricacies. But let me focus on one question that you asked, the question of complementarity or overlap between the various legal instruments. And I've been thinking about this for quite some time, not only because you asked it, but because this is an issue that featured quite prominently during the negotiations of the Convention. Extra care was given in those negotiations, in the development of the formulations of the various provisions of the Convention, to ensure that the instruments that existed before it, and which also served to a large extent as a source of inspiration for this Convention, would not be affected by the new provisions. Both the Council of Europe and the OECD Convention pre-existed the UNCAC, and so did the Inter-American Convention, which was the first, in fact, to come into play and to put its mark in the international arena as in a normative way. There may be differences in the way that the instruments are implemented. Or, I should say even more, there may be differences in the way that the mechanisms to monitor implementation function. But I would suggest to you, and there are colleagues here from both other mechanisms, at least that operate at least in this geographical area, both the OECD and the Council of Europe, and they will bear me out. I think this has to do more with the size of these organizations, the number of countries that are to be monitored, and resources. A key issue, particularly in this time, since we are going through a difficult period, particularly with the financial crisis. I can only speak about our own mechanism, which has been operating for 3 years now. The implementation review mechanism of the Convention, which was established in 2009. It started functioning a year later, in 2010. This was an act of faith because it was, the task was enormous. The task was to establish a mechanism for a convention that covers virtually every country, every region, every level of development, every legal system that exists on this planet. And therefore, a lot of challenges came from that. A lot of fears, a lot of concerns had to be overcome. And the functioning of the mechanism so far, in its 3 years that it has been operating, has shown that it was good to have faith. It was good to try new things. It was good to put our collective minds together in order to be able to go through negotiations which on many occasions were even more difficult than the negotiations for the Convention itself, particularly because of those fears. The mechanism has proved so far that an issue that like corruption, which can be easily politicized, and it can be used as a political instrument, sometimes as a blunt political instrument, can be approached from a technical, professional, non-politicized perspective. And I think if we were to, in the interest of time, summarize the experience that we've had so far from the mechanism, I would, if I had to choose, I would choose that. I would choose the ability of the mechanism to be serious and to be substantive and to be technical. We will soon be entering the, should be finishing the first cycle of the monitoring of the convention, which covers 2 chapters on criminalization and on international cooperation. And here in the Russian Federation, as Mr. Dubik mentioned, when we come back for the conference in 2015, we will be launching the second cycle, which will cover the chapters on prevention and asset recovery. And we are beginning to prepare on these issues, particularly on the question of prevention. But of course, what I'm about to say applies to the entire convention, not only to prevention, but particularly in the case of prevention, we are every day realizing how vast the effort must be, and the fact that it can only succeed if all interested stakeholders are involved. And this is of particular importance, especially perhaps in this forum. About 2 years ago, the International Bar Association, with our support and the support of the OECD, did a survey among its members and focused primarily on those of its members that performed the functions of corporate counsel or were in one way or another advising businesses. The results surprised everyone. Only 35% of those surveyed had any knowledge of any international legal instrument against corruption. Only 35% of lawyers who are either functioning as corporate in-house counsel or advise companies as to, as you yourself said and Mr. Dubik mentioned, as to how the corporate sector should behave in order to support this function. You will notice, Mr. Chairman, that I am not speaking about compliance. And I'm not speaking about compliance for a reason. In the last 6 or 7 years, significant progress has been made in the private sector in order to confront the issue of corruption and to pool its weight in the joint effort against it. A lot of progress. And Mr. Dubik mentioned the progress that has been made here in the Russian Federation with the Charter and so on, which I must say we were particularly honored to be able to comment on and so on while it was being drafted. And there's also the work that is being done now in the B20 under the Russian leadership while Russia holds the presidency of the G20, the B20 being the mirror group from business. But if you pay a bit closer attention, you will see that while on almost every other element of corporate social responsibility, to take an umbrella meaning, an umbrella term, on every other element of that concept, we have a positive approach. We speak about protecting labor rights, protecting human rights, protecting the environment. When we come to corruption, what do? We speak about compliance and risk management. In spite of the progress that has been achieved, I would suggest to you that still the narrative is negative, and it needs to change. It needs to change in the sense that the corporate sector needs to understand and to comprehend deeply that it is anti-corruption, active, proactive anti-corruption work is good for business, is good for the bottom line. And, we sometimes in the area of advancing the rights of women, we speak about a glass ceiling that women face to enter the corporate boardroom. Well, we are also facing the same. Anti-corruption activists and fighters are also facing a glass ceiling. We have not been able to enter the corporate boardroom. And I think it's about time for all of us to work together to do that. One such opportunity is the opportunity afforded by the Conference of the States Parties, which takes place every 2 years. We spoke about this, about the one that will take place in 2015 here in the Russian Federation. The one coming up this year is going to be in Panama in November, and we're hoping there, with the help of some of our champions, Russian Federation being one, Mr. Dubik in particular, whom I wish to thank personally for all his support, with some of our champions also in the corporate sector, World Economic Forum, the International Chamber of Commerce, the leadership of the B20, to try to change the narrative, to try to create momentum in order to not speak about compliance and risk management, but speak about corporate action against corruption. We're hoping that we will be using this opportunity, and I hope that I will have the pleasure of seeing all of you in Panama in November. Thank you very much.
Спасибо большое.
Thank you very much, Mr. Vlasis. Thank you very much for a very interesting and very to-the-point speech. And right now, I would like to give the floor to a person who is now head of the Congress of the Local Council of the Council of Europe, and who used to be the executive secretary of Greco, and who is my very good friend, and also one of the founders of the International Cooperation for Anti-Corruption Actions. He is also one of the authors of the European Convention for Anti-Corruption, Mr. Le Certois.
Thank you, Mr. Chairman. Thank you, Maxim. It is true that we've known each other for long years, and we've become friends, working together in Strasbourg. And thank you for your inviting me, and through me, the Council of Europe, to participate in this impressive panel with so many top intellectuals and practitioners, experts in the area of fighting corruption. My role is to deal a little bit in a short time, in a nutshell, with the Council of Europe action against corruption. But before this meeting, I'm telling you a secret. The chairman, Maxim Travnikov, the vice minister, called a meeting of the participants, and he said, you should also speak about this and the other. And one of the things he said was, you should try to compare, coordinate what the different organizations are doing. And there are too many conventions, too many mechanisms, how though they cooperate. This is an issue which is worrying. Some people don't understand. So I will start by that, if you allow me, Mr. President. I will say you that it is true that since the 80s, and in the aftermath of the struggle in the fight against money laundering, the anti-corruption, the international dimension of the fight against corruption started and developed in different fora. But I have to say that these different fora have a different approach, and we've heard already some of the difference between previous speakers have already pointed out, and you will hear more about that later. We do not face corruption. We do not, the different organizations do not have the same reasons to fight corruption. The Council of Europe has an approach. The OECD has an approach. If we take the most famous conventions which are represented over here. We have, for example, that in the European Union, the approach was to fight corruption because it was detrimental to the budget of the European Union. Because it was a lot of money of the European Union which was going down the drain because of corruption. If you go to the OECD, and we have Patrick Moulet here, the emphasis was on preserving competition, fair competition in international business transactions. That was the focus. The UN, it is true, came a bit later, but one of the main things, Dimitri Vlasis has already mentioned, one of the main issues in that convention was the negotiation on recovery of assets. That was very important for the international community because through corruption, the money of developing countries goes to rich countries, and it is important to establish mechanisms that allow for the possibility of recovery. In the Council of Europe, the emphasis is entirely different. For us, the issue is how to protect democratic systems, how to protect the rule of law, how to protect human rights. Corruption is a phenomenon which goes against everything we stand for. It undermines democracy. We can see that in these times. In many countries, people just don't believe in these institutions, don't believe in the laws, because they say, well, this is just money for the politicians. If you want a living democracy, you need to have a very strong anti-corruption stand. And this is the role of the Council of Europe, to defend democracy and democratic institutions. This is also the rule of law. The rule of law means that we are all equal before the law, that the law applies to everyone. What does corruption? That's the contrary. I don't apply the law to you because you pay a bribe. But this is precisely what we're trying to avoid. And the third thing is against human rights, the right to property, or the right to equality. This and many other rights are violated thanks to corruption or because of corruption. So the approach of the Council of Europe has been to tackle corruption from this wide perspective. And this has led to several characteristics. First, it is the multidisciplinarity. Corruption is not only, and Dimitri was saying it a minute ago, it's not only an issue, a negative perception of sanctions and penalties. It is this, of course, but it's other very important issues like prevention, like civil remedies, like codes of conduct, like recruitment procedures of public officials. It's many things. The perspective of the Council of Europe is a very wide one, but all the branches of the law have to be involved in this part. It's also a multi-layer effort. It concerns all types of authorities. It concerns even the private sector. And third, I would say a very important element is that the focus in our case is essentially on monitoring. You can say whatever you want about corruption. We are the champions of against corruption. We will have adopted this law, this other law, this other law. We make splendid declarations. People will not believe a word unless there is a credible system of monitoring how this is applied in practice. And this is what we have tried. In the case of the Council of Europe, the funny thing is that before we had these standards, before we had the conventions, we already had the monitoring mechanism. We didn't have anything to monitor, but we had the monitoring mechanism, which was very, I know that some of the members are here. The Russian members of these mechanisms are here, I think, or I saw them earlier. The idea was that it should be a flexible, adaptable, but a strong monitoring mechanism. And this is what GRECO is about. It can adapt to the circumstances. It works in evaluation rounds. It can choose the focus of each round, but then it goes deeply into the topic. It is presently conducting its 4th evaluation round. The first one was on the independence of anti-corruption mechanisms and immunities. The second, I can't remember now. There was a second one on criminalization. There was a third one on political party funding, very important issue for prevention of corruption, indeed. And now they have just starting first year of the 4th evaluation round, which concerns corruption in the judiciary and corruption in the legislative bodies of member states. It has still many other issues which have not been monitored yet, but yeah, I would say that in this period of time, since 1999, when I started as secretary of GRECO, I'm not the secretary anymore, but GRECO has achieved most of its promises. It reunites now all the Council of Europe, also all European countries. Since 2007, also Russia. There have been 2 evaluation reports on Russia and several compliance reports. It seems that Russia is doing well, by the way. I was told that the visit to Russia was the best one ever organized in GRECO's life. There are many things which remain to be done, but in next month there will be published the annual report for 2012, which shows that after 3 years of the recommendations are issued by GRECO, 98% of them are applied. So this is a dynamic process which leads to improvements, specific improvements, which are very practical sometimes, but it shows that the system is working. There is a lot to do. Corruption has not disappeared. It may even have increased, but the mechanism and the reaction of states are being active and are following GRECO recommendations. To finish, I mean, I could, like Dimitri, I could speak for hours on this, but I would like to finish by something he has said himself, and it's connected with my present post as director of the Congress of Local and Regional Authorities. Normally, anti-corruption measures require laws. These are adopted at national level. But there is a lot of things that need to be done in the future to prevent corruption, to make it more difficult. And we need to associate all levels of administration. The Congress of Local and Regional Authorities of Europe is aware of that. It has adopted a code of conduct for local and regional representatives, and is now going to launch a campaign with the municipalities of Europe in order to try to develop the adoption and the monitoring of the application of these codes of conduct. I think this is a very important step to deal with issues that would otherwise facilitate corruptions. issues like conflicts of interest, issues like acceptance of gifts, issues like revolving doors, etc. And I think there is a lot to do and to promote, and also to raise awareness among local and regional authorities in Europe about the importance of this issue to save local and regional democracy in our continent. Thank you very much, Mr. Chairman, and I'm sorry if I spoke too long.
Спасибо большое, Мануэль. Я действительно уже...
Thank you very much. It has already been said in this room that exactly now, in these days or even minutes that we sit here at the forum, the Russian Federation is undergoing the second phase of evaluation of compliance with OECD Convention requirements. I spent the first half of this week in Moscow together with the delegation, and I wasn't sure that Patrick Moulet, Secretary, head of the Anti-Corruption Department of OECD, would be able to join us today here, but he managed to do it. He has come over to St. Petersburg, and this is a good sign for the Russian Federation, which probably means that the survey of Russia is going in the right way and the results are quite good. I would like to give the floor to him.
Yes, I think you rightly pointed out something which is will happen, and in fact it's interesting that I was thinking about what could be the main message of this presentation. I think it's important to show that international convention against corruption have impact, that they are not just pieces of paper, and I'm talking of all conventions, and precisely because now in Moscow there is discussions, meetings related to the review of Russia's second phase of implementation of the convention. I think this is very timely. So the anti-bribery convention is a very specific instrument. It's a very short treaty, only 17 articles, so it does not address all the forms of corruption like the United Nations Convention Against Corruption or the Council of Europe. It has a very specific purpose, and the purpose is to fight the bribery by individuals or companies, the bribery of foreign public officials in other countries in order to get markets and contracts. So this is very specific. We call it the supply side of bribery. So we have our role to play, the OECD, probably because in OECD the E means economy, and this is our function to work in this particular field. So I think we are not really overlapping with other international instruments. And I would even say that there is more complementarities and even synergies between international conventions. It's again, a very specific instrument, only one form of corruption that is called the supply side of bribery. It's interesting also to note that this convention, we call it the OECD Anti-Bribery Convention and the OECD Convention, but I don't think this is legally correct. In fact, it is the Anti-Bribery Convention. It could have been settled or homed elsewhere, because this is an open instrument. It's not only for OECD countries, it's also for other countries, the major economies, like Brazil, South Africa, and that's why Russia has joined and is one of the newest members of this convention. Another interesting feature of this convention, related to my first word, is about impact and action. And I think the monitoring system, which is literally enshrined in the convention, there is an article which mandates the state parties to undergo regular evaluation of their implementation of the convention. This is also quite original, and in fact, it has led to what I believe is a rather rigorous and in-depth system for reviewing how state parties implement the convention. I can tell you, being in Moscow this week in the phase 2, I don't know what Mr. Krasnikov thinks, but it's really, you start the meeting at 8 o'clock in the morning and you finish at 8 in the evening, and all the day with only half an hour to have lunch, and we meet with experts from the Ministry of Justice, from the Investigation Committee, and the questions are ongoing. I mean, it's very in-depth. Again, that makes a link with my point about impact and action. Conventions against corruption, they must mean action. So there is this regular and mandatory system for review of the implementation for all the state parties, for the 40 state parties. And it is interesting that the report is not done just for the sake of having another piece of paper. The report contains recommendations, and the report is public. All the reports are public. You can find them on the website of the OECD. Maybe just to be a little bit concrete, what has been the payoff with this huge work? As you can imagine, it's quite intense to have a permanent system of review of countries' progress. So in many, many cases, what we see after a review is an improvement, a stronger system for combating bribery, better results in enforcement. The results vary, of course, according to the countries, but two very obvious examples of the result of this review monitoring system. For example, the UK Bribery Act, after quite some time of difficult dialogue with the United Kingdom, finally, and this is one of the best legislation in the world, that's what people say and generally recognize as that. And also I could quote another example, the ongoing efforts and progress by the Russian Federation to strengthen its own system for fighting bribery. So again, it's not only a theory, it's not only a piece of paper, it is actions, and these actions, the theme of actions versus words, can also be shown globally, if you wish. This convention is certainly a beautiful piece of paper for lawyers, it's legal material, but in fact it has concrete impact on people's life, on business. Since the entry into force of the convention, 300 companies and individuals have been sanctioned against criminal proceedings for foreign bribery. I can discuss maybe this is nothing, this is not enough, but at least it's not the convention itself, obviously directly, but indirectly, this is, I think, an important and significant outcome. And even further, at least 60 of these individuals have been sentenced to prison for foreign bribery. So sometimes we make this allusion that with the convention you can put people in jail. It's not as simple as that, but I'm just trying to show that there is some impact in concrete life. Yeah, that's, I think, the main point of my presentation. I don't want to speak for too long, so I hope I have shown my modest contribution that international conventions can mean action and results and impact. And in this way, I hope I have shown that how the state parties to the convention work together so that bribery is not business as usual. Thank you.
Спасибо большое, господин Мулет, и спасибо еще раз.
Thank you very much, Mr. Moulet. Thank you very much for being able to come over to St. Petersburg despite your very intensive work in Moscow. Thank you for taking part in our roundtable discussion. One of the newly established intergovernmental institutions in the field of combating corruption is the International Anti-Corruption Academy. As I said, at 11:30 we are going to have a presentation of this academy, but still now I would like to give the floor to the dean of this academy so that he describes his vision as the head of this institution with regard to the role of the Academy in resolving those tasks and issues that we are discussing here. Mr. Martin Kreutner, you have the floor, sir.
Thank you very much, Mr. Chairman. Thank you also for inviting me. It gives me great pleasure of being here. Let me at this stage also commend the organizers of this conference for hosting it in such a marvelous place like St. Petersburg. It's a privilege also in representing the International Anti-Corruption Academy, which, as the chairman already said, is a pretty young intergovernmental organization. We hosted our inaugural conference in 2010, September, and as of now can already bring together a constituency of 66 countries and other international organizations, out of which 44 have already ratified the founding treaty. And again, let me also commend and thank the Russian Federation in this regard, being a very strong partner from day one in this initiative, and also having Mr. Dubik on the Board of Governors. So my gratitude goes also to your country. I will be pleased to inform and pleased to provide additional information on the organization on the occasion of the presentation immediately afterwards this panel, which of course I would like also to extend an invitation to all of you, but would also like, with your permission, Mr. Chairman, come back to a few of the issues that have been raised not only by you but also by some of the previous speakers. First of all, the contradicting elements of international conventions. Are there contradictions? Is it rather an issue of complementarity? I basically, in my humble opinion, was involved in quite many of the, at least European and universal instruments that have been mentioned so far, and frankly, I do not see any contradicting elements in them. I would rather say they follow a common bus and also have common denominators. And let me outline these common denominators. First of all, it is, of course, the latest international instrument, which is the United Nations Convention Against Corruption, which, as Mr. Vlasis already mentioned, brings together 166 countries of the 193 of the UN, and is basically undisputed all over the world. Secondly, and this was mentioned by Manuel, we also have the Universal Declaration on Human Rights. Corruption actually is the antithesis to human rights, is the antithesis to security, is the antithesis to the rule of law, is the antithesis to justice. So if you recall what is written in Article 1 and Article 6, for example, of the Universal Declaration of Human Rights, corruption is just the opposite. And on a very practical note, and I'm positive that you all can agree to that, a common denominator also is that I do not know of a single society, of a single family, of a single tribe, of a single region that would like to live in a corrupt environment. So obviously we have a very clear common denominator, a very clear global denominator that actually should bring us together and should form the basis for our action, hopefully collective action. What we need to do, though, is stop what I call the monopoly business. This has been mentioned as well already. Until the middle of the 90s, we thought corruption and fighting corruption is basically a national issue only, full stop. We were very strict on not letting other ones engage into or get involved. This also, of course, applies to the relationship public sector versus private sector. Not only was delinquency a monopoly of the public sector, at least with regard to perception, but also was the responsibility only with the public sector, and there only with the government. I think it needs to be understood that this is a common thing. This is a thing that needs the involvement of everybody, needs the involvement of all sectors, and therefore definitely also the involvement of the business sector. With regard to international cooperation and basically all the conventions, especially the UNCAC, dedicates entire chapter to this need of international cooperation, of cooperation among all stakeholders. I again can only echo what already has been said and see it as a positive step in the right direction are the peer reviews. Peer reviews that are being conducted by the instruments that we already heard of, but also, for example, by the Convention of the Organization of American States within the so-called message mechanism. So this is an instrument that has proved valid and has proved fruitful in further developing not only international cooperation, but also national legislation. And I can only echo what Manuel also has said, and having been involved in quite so many reviews, including the review of the Russian Federation. Also in my understanding, it was one of the most professional and best organized reviews that I ever was involved with. And let me also extend my congratulations there too. With regard to the involvement of the business sector, we, especially in the international sphere, have been calling in previous years, especially for the involvement of civil society, for the involvement of NGOs, the media, and so on and so forth. I think we also need to come to the point where the involvement of the business sector is more prominent in our deliberations, is also more prominent in our undertakings. And Mr. Vlasis mentioned it. One forum there too definitely could be the G20 and the B20. So I'm a strong promoter also, and would also call for this not only public civic anti-corruption model, but also this public civic business anti-corruption model. We have been briefly discussing about, and Patrick was doing so especially, about demand and supply. Let me come back to one of these common denominators. The common denominators that there obviously is not a single society, not a single tribe, not a single family, not a single region on the globe which would like to live under corrupt environments. So there is obviously a global demand. Interestingly, what is missing is global supply, especially with regard to the business sector. So what I see a possibility in is, why not go for a corruption-free business model? A corruption-free business model that is a benchmark in itself. And what was mentioned also is, and I think this is very clear also with regard to recent studies, recent surveys, is ultimately the corruption-free business model pays off. And it needs to be understood, again, as Mr. Vlasis has said, that anti-corruption also is good for businesses ultimately. If the International Anti-Corruption Academy can provide neutral ground there too, and a platform for direct dialogue, for collective action, we would be more than happy to do so. And I am positive that this is definitely also a role that the Academy can contribute to. In concluding, let me also, however, share one caveat with you, a caveat that is quite dear to me for the fact that it is important in my understanding. What we need to stand up against also is what I call an anti-corruption bad news industry. An anti-corruption bad news industry that came up in the recent months and years and blaming those who are engaged in fighting corruption for not bringing a social change within the shortest possible time. Again, I think it is something that we all need to stay concerned with, and everybody needs to get involved, and we also need to be patient. Rome wasn't built in a day, St. Petersburg wasn't either, so it took human rights, as we have been discussing human rights as well, roughly 170 or 200 years, it depends on the time you see the discussion starting. The anti-corruption agenda is on now roughly 15, 20 years. I think we have progressed tremendously over the last 10, 15, 20 years, but there are still hurdles in front of us. This will stay an uphill battle for the decades to come, but we need to stay engaged. And last but not least, Sergei was mentioning that it shall not be and it must not be a one-off affair. I would also subscribe to this notion. Yes, it's about implementing international conventions, it's about enforcing them, it's also about developing them, but as has been said, we also need to form the alliances that are needed. Therefore, the alliances among all the sectors, and this definitely also includes this business sector. Thank you very much, Mr. Chairman.
Спасибо большое.
Thank you very much. Mr. Kreutner. One of the constant participants in our forum in St. Petersburg, and probably one of the most noticeable and speaker on many panels, I would say it's a very famous judge, Mr. Wolf, and a lot of people know him through his speeches that he delivered on other platforms, and I'm very thankful to him for agreeing to participate in this meeting, especially because he was one of the speakers and co-moderators on our previous anti-corruption panel, which was held 1 year ago, where he voiced an idea of setting up an international anti-corruption court. So I'm giving him the floor with great pleasure.
Thank you for that very gracious and generous introduction, and more particularly, thank you for the opportunity, the very rare opportunity for Americans these days to sit with their Russian counterparts, as well as people who share our deep interests and are expert, and have candid civil discussions on issues that really are profoundly important. In the United States, there's a very popular television program for young children called Sesame Street. And almost every day, there's a little exercise for these 1- and 2-year-olds, and they show various items and say, one of these things is not like the other ones. And the child is supposed to learn how to pick out the one that's different. I feel like I'm in that Sesame Street program. I'm an American, the only American, but more particularly, I'm the only person, I think, who is not professionally, primarily engaged in these anti-corruption efforts. I am a judge in the United States. I'm a United States trial judge, and I will try a range of cases, commercial cases, patent cases, mafia cases. But I do have a longstanding passion concerning combating corruption. When I was 28 years old, I became an assistant to Edward Levy, the Attorney General of the United States under President Gerald Ford, who was appointed to attempt to restore and succeeded in restoring confidence in our administration of justice after Watergate, where one of the most serious abuses of power was the use of the power to prosecute for partisan political reasons. And years later, I became a prosecutor of corrupt public officials myself in Massachusetts. My colleagues, one of whom is here today, Mike Kendall, and I won more than 40 straight cases, and I received a very high honor of becoming a United States judge, one of 850 federal judges in a country of more than 300 million people. Last year, I did introduce at the panel on corruption, combating corruption, the provocative idea of whether there's a need for an international corruption court comparable to or perhaps part of the International Criminal Court. The essence of my thesis was and is that in some countries there is a culture of corruption that begins from the very top. And people at the very top are not going to encourage or indeed permit investigation and prosecution of themselves and their closer colleagues. And I particularly mentioned a country with which I've been involved since 1974 in Africa, Gabon. When the president of Gabon, which has much oil and strategic minerals, died after about 30 years as president, 6 or 7 years ago, the newspapers reported that he was the second largest property owner in Paris. You can't do that on a public salary in the United States or any place else, to my knowledge. And in my view, It is the real threat of criminal prosecution that has the potential to end the culture of impunity that exists in many countries and creates opportunities for the people who I do believe want honest government everywhere to elect more honest officials. The International Corruption Court, as I discussed it, would operate on the principle of complementarity. That is, any country that had both the will and the ability to investigate corruption and prosecute it itself would not be subject to the jurisdiction of the International Court, which is comparable to the International Criminal Court fundamental concept. As has been discussed, and if we were in another country, I think I would perhaps use other examples. Corruption is a serious problem in Russia. The world, it's an economic problem, and you've heard this much more authoritatively from others. But the World Bank, from what I've read, has estimated that corruption costs Russia 48% of its gross domestic product. And I would say there's something that's barely been mentioned yet that is more significant, more fundamental, and that is corruption is a threat to the stability of any nation. The great United States Supreme Court Justice Louis Brandeis wrote in one of his opinions, actually a dissenting opinion, not everybody agreed with him, "Our government teaches the whole people by its example. Crime is contagious. If the government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. It invites anarchy." And I was impressed when I read then President Dmitry Medvedev recognizing this when he said that corruption was a key threat to Russian modernization and social stability. And I interpret President Putin's recent initiatives as further recognition and concern about that fact. I've been greatly educated in preparing to come here today, and particularly by listening to people who are fully employed in doing this work, to understand that Russia now has many laws and mechanisms to combat corruption. I hope it won't be regarded as inconsistent with the generous introduction. I hope it won't be regarded as unfriendly or undiplomatic if I speak the way I speak in the United States to sometimes powerful people. If I raise some questions and express some skepticism, perhaps, global integrity based in Washington, D.C. has very sophisticated metrics and many people in many countries who do evaluations. And in its evaluation of Russia with regard to corruption, in its most recent report, which is only 2010, and I recognize may be out of date, noted and appeared to document a gap between mechanisms and performance, a gap between the measures that you've been describing and how they were actually performing. And in our courts, great lawyers like Professor Charles Ogletree here educate juries with stories. And I would just relate 3 anecdotes, and people who are more expert may tell me that the questions they raise are not well-founded or not representative. But there was a Foreign Corrupt Practices Act in Brooklyn against Daimler-Benz, the Mercedes people. And in April 2010, Daimler in the United States pled guilty to violating the Foreign Corrupt Practices Act by, among other things, paying more than 3 million euros in bribes to Russian officials who were acquiring vehicles. And Daimler Russia, the subsidiary, paid a $27 million fine. Daimler, as part of its plea agreement, agreed to cooperate, to testify, to provide information to foreign authorities. And I've read this, I have the transcripts in my bag. Alexei Navalny promptly publicized this information in Russia. Then President Medvedev pledged that the matter would be pursued. When I was here last year, I asked, has anybody been prosecuted? And I understood the answer to be no. I've had my brilliant young assistants look, and it appears that as a result, there still have been no prosecutions in this country. Similarly, in 2008, Siemens admitted to paying $741,000 in bribes for a traffic system in Moscow. The World Bank thought and did find that it should be barred, that it should bar Siemens Russia for 4 years. Siemens also acknowledged, as part of a settlement with the United States Department of Justice, paying $55 million in bribes for medical equipment business in Russia. In 2007, Germany released the names of 12 Russian officials who allegedly were bribed by Siemens. And again, and perhaps it's not all translated, although I did have a brilliant young lawyer from Moscow State, who of course is conversant in Russian, help me with these figures. No prosecutions. In my country, I was just stopped coming in by a reporter from the Moscow Times, and I can't speak to the newspapers in the United States, but she asked me about corruption in law enforcement in the United States, and I said, we have it. We have it. And what distinguishes the United States, I believe, is that we take it seriously. As I said, I had become a federal judge at a very young age in my country as a result of our efforts, successful efforts to prosecute some massive corruption in Massachusetts. And in 2011, I conducted a 7-week trial and ended up sentencing the Speaker of our Parliament to 8 years in prison for taking bribes in connection with public computer contracts. So I am not here suggesting that the United States is perfect and anybody else ought to be just like us, except to the extent that we take corruption seriously. I mentioned a few moments ago that Mr. Navalny had publicized, brought to public attention, the fact that Daimler Mercedes was paying bribes. From what I have read, I understand that he also recently exposed secret ownership of luxury properties in the United States and Canada by 2 members of Parliament who resigned. He disclosed that Gazprom, whose bank has given us our nice lanyards, could have bought gas for 70% less directly, but used an intermediary, which paid $10 million to a consulting company formed using 2 stolen passports, obviously a shell for something. And he disclosed that VTB Bank bought oil drilling equipment through a Cyprus intermediary at a 50% markup. I know there's a pending case, and the merits of such cases have to be decided in court, hopefully impartial courts. But he is now, as I read it, being prosecuted, charged with corruption himself regarding timber contracts. The reports that I've read indicate that that investigation was closed twice, last year in 2012. But the prosecution was reopened after Mr. Navalny alleged that the head of Russian investigative committee had undisclosed real estate in permanent residence status in the Czech Republic. This sounded to me like it might be the kind of abuse in Watergate where as a young man, probably even younger than the deputy minister, I was introduced to the cost of corruption. This is a question. It's only a question, it is not an accusation. But from these anecdotes, hearing all of this discussion about treaties and conventions and measures and monitoring, and knowing a few examples that I think are not the only examples that could be cited, I come away with a question, as others do, I know, about whether these efforts in Russia to combat corruption are real, or rather a recreation of the proverbial Potemkin village, a facade without substance. And for the future of your country, for the future of our relationships, which are extremely important, I come from Boston, Massachusetts. The close cooperation and the investigation of the Boston Marathon bombing is a reminder that we're big countries, far away, with official tensions, but we are linked. And I and my country have done what I can, when I can, to try to assure that the promise of equal justice under law, which corruption is a betrayal of, is real and not just rhetoric. And I sense that I'm in the presence of some people who want the same thing for your country. And therefore, as I said, I hope it will not be regarded as unfriendly or undiplomatic for me to have shared those thoughts. Thank you very much.
Спасибо большое, господин.
Thank you very much, Judge Wolf. Thank you for kind of making our discussion a little bit sharper. You are among very few people who can speak whatever they think without taking into account any official positions, and this is good for our discussion today, I'm sure. We already said earlier that all our efforts are aiming to fight corruption at the international level will not lead to any results if it will just be an exercise for us only, international officials, workers of secretariats, and so on and so forth. This must become a natural process and a profitable process, including profit for the business community. And now I would like to give the floor to Irina Kotelevska, who has vast experience of working in parliamentary structures, but recently she became head of the Center of Monitoring of Legislation of the Russian Union of Industrialists and Entrepreneurs. She's one of the co-authors of the Anti-Corruption Charter of the Business Community, which is an outstanding example of consolidating small, medium-sized and large businesses in their fight against corruption and unfair competition. I would like to give the floor to Ms. Kotelevska. Thank you. So, Mr. Wolf, you said that you well know the scale of corruption in Russia. Probably we Russian businessmen know even more about the scale of corruption in Russia. We have heard a lot from the representatives of international organizations, thanks to whom the business community in Russia has taken decisions and practical steps aimed at launching real anti-corruption work. Of course, the business community is very pragmatic. They are not going to get involved in anything that is not profitable for them, which is true also for any country. But now it is time to work in the field of fighting corruption, not only through legislative initiatives, not only through regulations adopted by the state. We need to also adopt corporate norms and regulations, and this must be done by the business community. The business community in Russia is 20 years old, and over this period we've been through a number of stages in our development. The community has changed a lot, and I would like to point out that now we observe a trend toward consolidation of businesses in Russia. We have various associations of businesses of federal nature or uniting businesses of a particular sector. Our Union of Industrialists and Entrepreneurs is one of such organizations which works alongside with the Chamber of Commerce and Industry which has a long history and a vast experience. There are other business associations as well. And I would like, in the beginning, I would like to clarify that the idea of put together anti-corruption programs by the business community and to start implementing those programs, this idea was based on the initial steps taken by the government. And it's very important that the government is now creating conditions within which there is no other way. You need to move forward. Another factor that stimulates us is, of course, the growth of international measures and our participation in the work of international organizations. Without their experience, without norms and regulations that have adopted them, that have been adopted by them, and Russia follows general rules and regulations of the international law. This is a priority for us. Without this, we wouldn't be able to streamline the work of business community in this field. This work is far from being finished. Our Union of Industrialists and Entrepreneurs, as well as other business associations, so the pointer doesn't work well. Maybe could we somehow solve this? And I cannot turn the pages of my presentation somehow. No, this is the pointer. Okay. Well, what I'm talking about is that we organize annual surveys of the business climate in the country. And our union unites about 300,000 companies. We have chapters in practically all regions of Russia. And this large-scale survey that we carry out on an annual basis, I just wanted to quote some figures from this survey. Okay. In this survey, and every year the results are becoming more and more interesting, there is a special section devoted to assessing of the business climate in Russia by foreign companies and companies with foreign capital participation. These materials are published on our website, and I would like just to quote some of the findings of this survey. It shows that from year to year, the percentage of businessmen who evaluate their relations with the government officials in such a way, well, those are our most important documents related to improving corporate governance and fighting against corruption and bribery. This is the diagram I wanted to show you. So, attitude to business as one's purse. You see that it is about 50%. So about 50% of businessmen see their businesses as their own wallet. We use other issues as well, that such as unfair competition, level of protection, inefficient or ineffective government governance. And of course, the business climate in the country depends on all these important factors. This is another diagram that shows you how the members of our union, companies, use strategic planning instruments on a more regular basis from year to year. This chart probably is not very clear, but anti-corruption programs and practices are becoming one of the elements of such policy. And finally, what Sergei referred to already, that is the document adopted last year by largest business association in the country. So we have the Russian Union of Industrialists and Entrepreneurs, Delovaya Rossiya organization, and the Pora Rossiya business association. Our union adopted anti-corruption code of conduct a year earlier. They are the same in terms of content with this document. And this document contains 3 sections. Some measures are aimed at improving corporate governance. This is one part of measures aimed at improving corporate governance inside the company. The second group of measures is related to interaction with partners, and the third section is devoted to the relations between businesses and society and government. Not only with government, meaning law enforcement authorities, but the society at large. These ideas and programs wouldn't be implemented without those very important international instruments and practical recommendations. It wasn't mentioned before here. I would like to stress the significance for the business community of ICC directives, the International Chamber of Commerce, which contains a very detailed list of measures. We use those recommendations very actively. Mr. Vlasis mentioned that the analysis shows that only a small share of consulting companies working in the legal market is capable of providing services in the field of compliance and anti-corruption procedures. A month ago, in April, in the Council of Federation, we had a very broad discussion with the participation of many businesses and consultancy companies. A British consultancy company, which played a major role in this discussion, demonstrated complete ignorance in the field of actions undertaken by the business community in Russia, which was quite a pity, because one of our ideas is to promote those principles and technologies that we're discussing here today. We have a roadmap, and I'll be happy to take any questions, because I cannot load you with more details right now. There are appropriate organizational structures, there are tools which are not perfect right now. So now about the problems that we see, and we are planning to set up a system of certification of companies that accede to the charter. It's not about introducing just another quasi-tax for businesses. We just wanted to make sure that those who sign the charter and state that they follow anti-corruption policies, they need to be stimulated by the society and the government. They need to receive incentives. And for this work to be effective, we need to identify the criteria of such work. Mr. Kreutner was saying that we need model business strategies for different kinds of companies. This is something that we discussed with the representatives of the Ministry of Economic Development and Ministry of Justice and the Presidential Administration, because the Presidential Council, the Presidential Anti-Corruption Council is working in close contact with the business community, so the topic of criteria and evaluations is very important for us. The next topic is the topic of incentives. We are not going to do things free of charge, that's for sure. This is our register. You can look it up on the internet. Those are the companies that have joined our charter, such as Severstal, FSK, some companies from Rostov. I'm demonstrating, information on those, on Russian companies. Of course, Maersk is there. Inter-RAO US is joining us, Sinara, Urals Locomotives. So all these issues you can find on our website. You can learn more from websites of the companies. We receive appropriate information in the Union of Industrialists and Entrepreneurs. Now, about how Russia and our union participate in international programs. Of course, we work very actively within the framework of B20. We presented the results of this work in Paris. We hope that at the St. Petersburg Economic Forum we will be able to report to the head of state about our proposals in this field. Our experts are actively involved in evaluation procedures. I mean, the work mentioned by other speakers during this roundtable. We carry out research projects, monitoring activities, and there was one more idea I wanted to share with you. Well, this is it probably. We are starting our work in this area. The Chamber of Commerce and Industry has accepted quite a number of companies as members of this charter. So the work by Russian companies and foreign companies operating in Russia is part of their social responsibility. For many years, we published non-financial annual statements or reports by companies. Some companies, this is about criteria, they quantify their effectiveness on averted, in terms of averted damages. There are other measures and tools. And in conclusion, I would like to say that the next session is devoted to compliance procedures. This is a very topical issue, and here we are very much interested in having very good consultants, and Russian businesses are prepared to pay for that. But still, I would like to say that in the consultancy community here in Russia, there are companies that are quite competitive in the international market. Here, what we need is not only international business and trade links. Of course, we learned first about the UK and US legislation, but according to some of the members of our expert council, the latest laws adopted on the USA are on the verge of infringing upon jurisdiction of states. So there are certain doubts related to recently adopted laws in the United States, and probably it is worthy of discussion amongst the legal community. But of course, international experience is invaluable. We are thankful to the Russian government for their support. They help us to move in the right direction. But since business is pragmatic, results will follow. We all monitor each other's activities. Whether you behave appropriately or not, all this defines your reputation and finally your bottom line. There are no other arguments. And of course, there must be decent conditions of interacting with the government in the field of government procurement, in the field of investment, in the field of public-private partnerships. Those are types of cooperation that companies that are prepared to work honestly are very much interested in. Thank you very much, Irina, for a very interesting presentation. This is a very good occasion to learn more about the Charter and the work of the Union of Industrialists and Entrepreneurs. Probably it makes sense to learn more about practical work. So we have started talking about companies that work on the basis of principles of integrity. I would like to give the floor now to Vice President of VimpelCom for legal issues, Marina Dumina.
Thank you very much. Thank you for an opportunity to deliver a speech at such a representative and influential conference. And basically, starting from international reforms and conventions, we went down to the business management and corporate management level. So I would like to continue speaking about the thesis which Irina voiced, that is that business is very pragmatic. This is absolutely true, but right now at this level, at the current level of market development in Russia, most of the companies understand that if the development of effective compliance structure in a company, what it does in the long run, it increases the company's attractiveness for investment as well as increasing its competitiveness. Therefore, from a necessary evil, compliance has been transformed into a very attractive and extremely effective mechanism. And I can say that large companies have been for some time and quite successfully building compliance systems as part of their structures. What does it mean for a company? Well, first of all, it is an unequivocal acceptance of the code of ethics and corporate behavior, which also, of course, fights corruption as well as adheres to good and legal business practices. Why is it good for a company? Well, because using mechanisms to expose corruption inside of the company, that is much better than letting this information leak outside of the company, because there are a lot of risks both in international legislation, which I cannot really talk at length about because I don't have the time. There are also material risks such as penalties, such as judicial proceedings, and of course huge risks related to business reputation. That is why the companies are extremely interested in development very efficient compliance systems and compliance mechanisms. So as the codes are being introduced, the companies develop internal audit, which can raise red flags by the management and the shareholders about the violations that take place in the company that also result in violations of anti-corruption legislation. That is also hotlines. It really works in our company because these hotlines, they provide anonymity to any caller and provide an opportunity to callers to report about corruption and possible violation of law, which in turn allows to settle this problem before they go outside of a company. Well, again, since I don't have much time, I would like to touch upon a very interesting topic, which is probably for Russian lawyers, so which does implement anti-corruption legislation. In 2010, in the USA, they adopted the Franco law, which was a response to financial cataclysms happening at that time. So one of the principles of this law was paid for reporting. I think Sergei, or whistleblowing, Sergei already mentioned it. Well, we thought a lot about the translation about it into Russian, whether like a reporter, an informer, somebody who tells on somebody. So, but a whistleblower is a person who has an opportunity inside of a company, even before the management or the auditors are informed. This person has an opportunity to contact the U.S. Securities Commission, submitting a document, and the investigation will be started. I can say one more time that these measures are already implemented and American employees have an opportunity to do so. And this is paid for whistleblowing. First of all, it goes that the violation should be more than $1 million, and the reward is from 10 to 20% from the amount that is being violated. So, well, of course, this is an incentive, but whistleblowing and prevention, of course, can save a company from even a bigger evil. But on the other hand, there have been a number of opinions voiced in America because it leads to an unhealthy environment within a company when people hide everything from each other, and then some people are waiting for the violation to exceed 1 million in order to get a bigger reward, which also does not lead to early detection and prevention. And another thing is for us to consider is whether it is viable at the Russian market, this whistleblowing for reward policy. Because again, in the Western culture, whistleblowing is quite traditional and even heroic within the discourse. But as our practice, or as our business practice shows, or even legislative practice, when they try to introduce these incentives, they were not always effective. Sometimes it is just outside of the discourse of the Russian culture. Well, unfortunately, I cannot answer this question right now, whether this reward-based whistleblowing can really take root on the Russian soil, but at the same time, a lot of the companies have already started implementing different policies, tools, and instruments which provide incentives or incentivize their employees to report violations for a reward. Well, about the law which was accepted in the US, I think around 10 companies, including Microsoft and Hewlett-Packard, they submitted a request that a provision should be made that before it goes outside of the company, it should be started as an internal investigation, and the whistleblower cannot be fired, cannot be persecuted in any ways, which might also be relevant for us. And again, since I don't have much time, I would like to conclude by saying that business is extremely interested in having very clear, very understandable anti-corruption mechanism. Mr. Vlasis said that only 35%, and I was extremely flabbergasted to hear about the statistics, that only 35% of in-house lawyers know about these international standards. But since in-house lawyers do not take part in everyday business operations, I think that if we have a very clear system, a very clear mechanism, a very clear corporate governance standards, then even without going into fine detail of international conventions, I think that would be extremely helpful. It would enliven the business climate and contribute to its development. Thank you. Thank you very much for an extremely interesting speech. I think that you've touched upon several topics which call for, I think, an independent panel maybe for the next forum. But looking at my watch now, I see that we are way behind the schedule, so we have to move to the presentation. That's why I would like to apologize to everybody that I'm not giving you an opportunity for a discussion. But let's continue discussing these issues during the coffee break and as part of other roundtables on similar topics, especially on the topic of compliance. And right now, I would like to summarize or give you the gist of today's discussion. And I'm pretty sure that it will not reflect the opinion of everybody present here today, but I think that the overall feeling and then the overall mood of the speakers was that maybe the doubling of functions of existing international instruments is not that important, but what is important is disseminating knowledge about these instruments and the understanding of these instruments in the business sphere, well, in society as a whole, but especially in the business. So I think it is very important that work that is being done at the government level is closely related to corporate life, to business life, to the problems and challenges that the business sphere faces on international markets when they encounter situations where honest behavior of a company is a weak point is their weak point when it comes to competing with other market players or for other market shares. So here I think that can be solved by uniting entrepreneurs or setting up such international structures as the International Anti-Corruption Academy, which should work hand in hand with business and international governments, as well as giving opportunity to corporate lawyers who are given opportunities to corporate lawyers to work together with international organizations. And I think that this process is ongoing. Most of the conventions have provided certain formats to talk to business representatives. And I think this work is one of the priorities for G8 and G20, well, at least within the framework of the Russian chairmanship of G20. Well, this topic is also not just economic, but it also has a significant dimension of moral and ethic as well as human rights. And so here we have to view it as part of our global culture as a whole. It was also noted here today that countering corruption is not important only at top corporate or top public level, which is also important, but what is particularly important that local and regional authorities, as well as people from small and medium business who do not work with such huge amounts or do not go into international markets, it is very important for these people to understand this culture and the standards and to understand that it is profitable and beneficial for them to adhere to it, first of all, to avoid the problems, and second of all, because these mechanisms, the existing mechanisms provide a significant incentive for them. Well, of course, here we have a number of issues related to, say, pilot measures, which are being implemented by several countries in the field of anti-corruption efforts. Well, it is very good. Maybe it will not be accepted overall by the international community, but I think some approaches will be used as basis for future instruments, and it will be used by other countries for regulation at a national level. So today, I would offer you to see today's discussion as a start of a much longer discussion, which will continue at this forum and at other forums, as well as the St. Petersburg Economic Forum, which is scheduled in about a month. And I think that this topic will also be discussed there. But right now, I would like to offer everybody to participate in the presentation, which will be delivered at the main staircase of the Anti-Corruption Academy. Thank you very much to all the speakers and to all of you for participating.